Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8. The agreement, I think, is a cap of 8, and just based on the criminal history alone in the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about the felony criminal history, the first page of his, or I guess, rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one, in January 2002. They all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that, and even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better, and he tells me he's ready to make that change, and he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can't. Hold on. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something, and I hope it don't hurt you, but I got bring up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it, and I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds. 'Cause I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or if it's, I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is, you're 51 now, 52?
51. ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this is
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation where he said the part about the baseball bat is not true. A dresser fell on top.
I saw that.
He's still not accepting
I
responsibility.
hit him with the cane.
Hold on,
I'm
don't speak
sorry.
over.
I'm so
I let
sorry.
you talk, so
I'm
don't
so
talk
sorry.
over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence. TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Devon Keith Barley? And Mr. Barley has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Barley. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings, so that's why we're here. So just also for the record, Mr. Barley, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board is.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be
So
helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's done an MRT. He tells us that he understands that he has a drug problem, but then still continues to do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would need a bond was so he could go work out of county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may. Go
can
ahead.
I ask her a question? When did you place him on JCDI? Do you have a date when his term? When was he actually placed in? Was it 2019? When he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions. And we believe outpatient would be the best for him. He had spoken to me briefly as well that he had, some issues he wanted to talk through. He had some family issues he wanted to talk through. So we've got him being in front of a counselor, him getting that drug treatment is what he needed. He agreed with us, that's what he needed. So we believe that outpatient program is the best option for him.
Did he go to JCDI?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, it wasn't him not going?
As well as the drug use.
And was there another program too, that you said?
He had done ISF, cognitive track.
And what is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else? Mr. Burbank?
Mr. Barley, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I believe I mentioned also to you that I would like to get into an outpatient program at that rate choice if possible, which will allow me to, I just told you I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, it is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I
you
work
would go to.
at, as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Okay, yes, ma'am.
You had a stroke last year?
Yes, sir.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
I had issues, and that's not an excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two was apartments, Mosaic Apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, it's probably Barley, also my mother, Barley, and I have an uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Port Arthur, in Fraser.
Do you have any kids?
Yes, sir.
And where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, and I got two kids here in Beaumont. One that I'm not allowed to see, and then also Tristan, who I just reconnected with Tristan, my 11-year-old.
Mr. Viola, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the patch. And I would guarantee, I
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, off of my word, even though the past doesn't.
That's right.
Yes, and that's one I told him, I see this as my last opportunity to keep everything that I have and not have to test.
One of the things is that you tested positive. What date was that, Your Honor? On the,
I don't know, Mr. Burbank, what date is it?
now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes.
Yeah, there was. So those allegations are true, correct? If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled, we're not sworn in, or, I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after. This is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them, let's work with them, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And the
That's fine.
assault, there may be a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Barley, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let me get this pulled up that way. I think I can do it. So will he waive the formal reading of the motion?
You will, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Barley, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Perfect. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, third-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates, and is that true or not true? Count 3 alleges in each case that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged.
Compliant, yes.
So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
Not true.
Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing.
Maybe excuse that.
Yes, sir, thank you.
I have one other thing to-
Give me just a second.
I thought you had the motion.
Well, I had it up here and I had other stuff here. I had some of it. It's hard to have them both pulled up and. Okay, yes, ma'am. What was it, 2, 4, and 7? He had 2, 4, and 7.
All but the new allegations. of the
Yeah.
possessions of assault.
Got it,
Well, the 2 allegations of it. And then there was one in reference to JCDI. but
got it.
we-
2, 4, and 7.
it wasn't-
Okay. All right, Brandon Dodd, Mr. Burbank. Good morning, are you Brandon Dodd? And this is 242418. Mr. Dodd is charged with murder, and Mr. Burbank, what is the announcement?
We have been, as you know, I'm the second, or maybe third attorney, judge, second attorney on this, just detained. I'm just asking for one more reset. We're almost up to speed. There were some questions I've gone over and talked at length with Mr. Dodd and just requesting more time. There is a co-defendant, but that doesn't make no difference.
Okay.
No objection, Judge.
All right, and so what I'll do, yeah, it looks like you've just been on it a short amount of time. Mr. Dodd, I'm going to reset your case one more time so you and Mr. Burbank can make sure you're both up to speed on everything that he's got, negotiations, and then we'll see if we can get an announcement at that next court date. All right, you can go back with the bailiff. see, is Mr. Kurtz? Yes, sir. Thank you.
2 courtrooms, 2 defendants, 1 judge who wasn't about to sugarcoat a single thing. The first case put Matthew Wadsworth front and center, a 51-year-old man standing before a Texas judge with a criminal history so staggering, the judge herself admitted she had never seen anything like it. 38 felonies, nearly 40 misdemeanors, a revolving door of incarceration, probation, and reoffense spanning decades. His attorney had somehow negotiated an 8-year cap on a second-degree felony, a deal the judge openly questioned accepting. Wadsworth spoke with raw honesty, the medication, the voices, the house fire that took everything, the walking cane mistaken for a bat. His remorse felt real. His explanation felt human, but the judge laid it out plainly. At 51, no one else can force you to stay on your medication. A society can't keep absorbing the risk. The cap was honored. 8 years, Texas Department of Corrections. Then came Devon Barley, a longshoreman, a stroke survivor, a father with a daughter coaching at Iowa State, and a probation record that told a different story. 5 administrative hearings. Repeated drug use. Crack cocaine found on him at 3 a.m. in a parking lot known for drug activity. The judge had seen probation bend over backwards to keep this man out of prison. Outpatient programs, cognitive treatment, ISF, all tried, all failed. No bond, case reset for sentencing. What connects these 2 men isn't just their records. It's the gap between who they say they are and the paper trail that follows them everywhere they go. Good intentions don't erase history. And in a Texas courtroom, history has a way of speaking louder than any letter ever could. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.